In real estate transactions, missing a deadline by even a single day can have serious legal and financial consequences. This is especially true when contracts include a time is of the essence clause. Understanding this powerful legal provision could be the difference between a successful transaction and a costly breach of contract. A time is of the essence clause is a specific provision in real estate contracts that makes deadlines strictly enforceable. When this clause is included, it legally requires parties to fulfill their obligations within the specified timeframes. Unlike ordinary contract deadlines that might allow for reasonable delays, when time is of the essence, failure to meet a deadline constitutes an immediate breach of contract. Not every deadline in a contract automatically carries this weight. Simply inserting a closing date in a real estate sales contract does not ensure that the date will be of the essence. Without this specific clause, both parties are typically entitled to reasonable postponements of the closing. However, when explicitly stated, an agreed time is of the essence closing date becomes strictly enforceable. Courts generally uphold these clauses when they are clearly stated in the contract. However, enforcement depends on several factors. First, the wording must be explicit about which deadlines are essential. Second, courts consider the conduct of the parties. If both have consistently allowed delays without objection, strict enforcement may be deemed unfair. Third, the nature of the transaction matters. In fast-moving real estate markets, courts are more likely to uphold these clauses due to the potential financial impact of delays. The clause commonly appears in several real estate situations. In property purchases, buyers must close on time to avoid losing their deposit. During contingency periods, sellers may impose strict deadlines on financing approvals or inspection completions. Commercial leases often include these provisions for move-in dates or renovation timelines. Construction contracts frequently use them to ensure timely project completion. There are circumstances where a time is of the essence clause may need modification. Both parties can mutually agree in writing to waive or extend deadlines. A party may also lose the right to enforce the clause through waiver by conduct, consistently allowing late performance without objection. Additionally, force majeure events like natural disasters may provide legal grounds to delay enforcement. Any modifications should always be documented in writing. One party may send a time is of the essence letter to the other as a formal legal notice. This typically occurs after a tentative closing date has passed. The letter specifies the time, date, and place for closing, and states that failure to meet these requirements will constitute a breach of contract. The sender must allow a reasonable time frame for compliance and must send the notice to all involved parties, including agents and attorneys. Ignoring such a notice carries serious consequences. The non-breaching party may terminate the contract entirely. Buyers who miss closing deadlines risk losing their earnest money deposits. Legal action seeking damages or specific performance is common. In some cases, the situation creates an opportunity for renegotiation, though from a weakened position for the breaching party. The enforceability of these clauses can vary depending on their clarity and specificity. A clause that is too broad may be viewed as punitive and deemed unenforceable. For maximum effectiveness, contracts should isolate particularly important tasks and indicate that the clause specifically applies to those items. Real estate transactions involve numerous time-dependent elements: option periods, document delivery, notices, termination methods, and closing dates. Every deadline in a contract typically stems from the execution date. When time is of the essence, failure to meet these deadlines can result in significant negative consequences. Before signing any real estate contract containing this clause, both buyers and sellers should fully understand their obligations and the potential legal remedies if a deadline is missed. Consulting with a qualified real estate attorney is highly recommended to ensure the clause is properly structured and your interests are protected in case of disputes. Remember that in real estate, time truly can be of the essence, not just as a legal phrase, but as a practical reality that can determine the success or failure of your transaction.